Chairperson, the distinguished Minister of Home Affairs, Mr. Robeson Ben, the hardworking and stressed out, I know stressed out because I speak to her a lot, Permanent Secretary of the Ministry of Home Affairs, the beautiful May Thomas, the Acting Commissioner of Police, Mr. Clifton Hickins, performing the functions of the Commissioner of Police, and other distinguished leaders of the Guyana Police Force, including, of course, the Court Superintendent, Ms. Daniels, the Solicitor General, the senior and junior legal advisors to the police force, our esteemed trainer, and the person who will be executing the workshop that we are all gathered here to launch, Queen's Counsel Darshan Ramdani, and all of you distinguished ladies and gentlemen. It is a privilege to be here and to be part of this ceremony. The rule of law, law and order, justice are all interwoven concepts that aggregate to constitute the foundation of every civilized society. Without them, everything becomes meaningless. In fact, there is no society whatsoever without those concepts that binds like a glue civilization together. Many a times we hear about infrastructural development in a country. We hear about economic development in a country. We hear about production in a country. We hear about educational advancements and pursuits in a country. They are all important. They are all important, but nothing is as important as the rule of law, justice, law and order. Because these concepts relate to life itself. And without life, everything else is reduced to zero. And what we are here to deal with are concepts and precepts that relate to justice, the rule of law, and law and order. The minister spoke about the fire at Breakdown. One single incident has devastated this country. One single incident. One wrong decision of a court can throw this entire country into frenzy. One disregard of a provision of the Constitution or a principle of a statute or a principle of law can cause a societal breakdown. We were on the verge of that for 5 months. So it's fresh in our memory. The importance of law, of constitutionality, of justice, and the majesty of the legal system. It's against that backdrop that I want to speak about the support for justice and the support for the criminal justice system, which is the project under which this initiative emanates. This is one of the several components which is encompassed in a very broad and embracing project and permit me to digress a little to speak about the other concepts and other components of the project, because they are not in isolation, but they relate to one another. They are strands belonging to the same rope, if you wish. So it is out of this project, for example, that we were able to make some significant donations to the Court Superintendent Office. We rehabilitated that office at Brigham, and we furnished that office with a large complement of required materials and equipment. Computers, printers, air-conditioned units, file cabinets, and desks, and tables, and chairs, and a whole host of equipment. Of course, it's all now in ashes. It is also under this project that we will soon again donate to the police force a large complement of computers and printers with the express intention that they are to be used for the typing of statements which are to be used as the basis for prosecution in the courts across this country. Anyone who have had a fleeting engagement with our criminal justice system, at least at the level of the magistrate's court, would know that the statements that are served, which are legally required to be served, are done in handwriting in longhand, and sometimes it makes very tedious and difficult reading. That hopefully will change, and this program will donate to the police force that complement of equipment, hopefully that the police force will use to remove this handwriting and handwritten statements served in criminal processes across Guyana. It is also this project that is producing a bail bill that is in its final stages. Bail is one of the vexed questions in our country, and I'll speak a little more about that when I concentrate my focus on the workshop that Mr. Ramdani will undertake after we leave here. Sentencing guidelines is another concept that we are working on, and the advertisements are out inviting expressions of interest of persons and firms that are interested in offering their services in that regard. So our judges and our magistrates, and importantly, the public will know what our sentencing guidelines are. So the days of erratic sentencing perhaps will disappear, or at least be reduced significantly. The Law Reform Commission that we recently launched is also a product of this project. And I want to use this platform to appeal to members of the public, civil society, and civil society organizations to make use of that important institution. The members of the public are free, and institutions alike, to go and lodge their request for law reforms or engage that body in areas that they think require law reform. That's the purpose of the exercise. Also in this project is the concept of the restorative justice. And restorative justice is a fairly new concept in our society, in the third world, and indeed in our jurisprudence. And simply put, it's a different side of rehabilitation and punishment. We are accustomed to incarceration, hard labor, the cat o' nine tail, solitary confinement, the brutal, if you wish, aspects of punishment and penal sanctions as prescribed by law. Those who are better educated than I am in this discipline have concluded that this approach, the harsh approach, may not have worked over the last century or so. And now they are recommending a different approach, a softer approach, an approach that requires a little more engagement and pursuing alternative method of punishment, alternative to imprisonment, pre-trial detention or alternative to pre-trial detention are all concepts that emerge from the precept of what restorative justice embraces. Minister Ben spoke about the prisoner after serving his sentence coming out as a repaired and rehabilitated individual and not a broken citizen. Restorative justice embraces that type of endeavors or those types of endeavors. But most importantly, it examines the root cause of why the person went into the criminal justice system in the first place. Because if that underlying or those underlying factors are still there, and he goes into prison and he goes back to that environment, and those underlying factors that precipitated his conflict with the law is still there, there is a likelihood that he will return. And that is a vicious cycle that the sociologists and the criminologists say have been confronting us, and we have failed to address it over the last few decades. Is it alcoholism in the household? Is it an abused child? Is the abuser still around? These are the underlying factors, circumstances, and situations that restorative justice enables us to investigate, find, and then address. Plaster the sore. That is a concept that this project embraces. Now to Mr. Ramdani's workshop. The workshop, as I understand it, I'm not a consultant, Mr. Ramdani is, and permit me to say who Mr. Ramdani is. Mr. Darshan Ramdani, first of all, he came through a process managed by the IDB, a competitive process, and he was chosen as the person qualified to conduct this workshop. He's an eminent Queen's Counsel, Guyanese obviously by birth, spent a number of years here, then migrated and held several positions in the Eastern Caribbean. He was Assistant DPP, then DPP, then Attorney General of Grenada. He also sat as a judge of the Eastern Caribbean Court and still sits on occasions on that court as it does its circuit around the Eastern Caribbean. So he comes to you with a wealth of experience, both in the criminal arena as a prosecutor, as well as in the civil realm as Attorney General. And the concept that he has been retained to interrogate is the question of pre-trial detention and its alternative. And secondly, to explore with you and to share with you the mechanisms, legal concepts and precepts and processes that are available to expedite the criminal trial. Let me pause here to observe that the burning down of the Breakdown Police Station will have a devastating impact upon the criminal justice system, at least in the magisterial district of Georgetown, because the court soup office, which was accommodated in that building, is the custodian of most, if not all, of the files in the criminal justice system in the Georgetown magisterial district. All those files have gone up in flames. Each one of them will have to be constructed, reconstructed, possibly being borrowed from the magistrate's court. That by itself will be an expensive, time-consuming, and very arduous exercise. But it will result in more chronic delay. More chronic delays. On the one hand, we are trying to bring speed and expediency to the wheels of justice. And then there are those who wish to put a spoke in that wheel, literally. And if they feel that by doing that, they are doing something against the government, they're absolutely mistaken. Robeson Ben and I are not under trial. The people of Guyana, those people, innocent or guilty, who are in the system, will now have to remain in the system. They number hundreds, their family members number thousands. They will suffer the injustice. They will suffer the inconvenience, not the government. And whenever these acts occur, whether they do it to a school or they do it to a police station, government is not fazed. Government is not affected. The people of our country are affected. Guyana is set back. I just want to interpose that and make that a very fundamental point. So Mr. Ramdani will investigate with you the concept of pre-trial detention. In Guyana, there is the view that bail is granted or refused irrationally and unlawfully. And that's a wide-held perception. All of that will be examined by Mr. Ramdani, because there is a corollary to that. And the corollary is judicial officers, conscious of that public perception, may now be forced to abridge the law, to infringe the Constitution, and remand where remand is not required under law. And that is because on the other side, you have had magistrates or judicial officers remanding when remanding, granting bail when remand was the proper recourse. So you have people caught in this vicious cycle Mr. Ramdani will competently address those intersections and collisions and will clarify them for you. Importantly, it is hoped that the bail bill will bring some clarity and consistency to these issues. And as I said, Mr. Ramdani will also explore the ways of how we can expedite criminal proceedings. Permit me to say that a few years ago, we enacted in our country a bill or a law to facilitate plea bargaining, where the prosecutor and the accused, in a legally permissible setting and based upon prescribed criteria, can negotiate and bring criminal proceedings to an end without the resort of a trial. That law was intended to bring great speed to our system and to remove from the system cases where an amicable resolution outside of a trial was possible. Unfortunately, the law was never used, in my view, for its intended purpose. I am told that there are some deficiencies in the law, and I am pleased to inform you that the Chief Parliamentary Council is currently reviewing that legislation with an input from the police legal advisors and the Director of Public Prosecutions, advising us where the deficiencies are so that we can remove it, so that that act can be used more beneficially and more usefully in reducing the criminal load on our criminal justice system. I think another component that Mr. Ramdani will deal with is the issue of alternative sentencing. One of the predominant factor that this project is designed to address is the question of overcrowding in our penal institutions. So what are the measures alternative to custodial sentence? The last thing I want to speak about before I close is something that Acting Commissioner Higgins spoke about, and it is about the construction of a management information system. That is another product of this project, and it is a work in progress. It involves the Guyana Police Force, the Legal Affairs Ministry, the Director of Public Prosecutions, the Ministry of Home Affairs, the Guyana Prisons, and I believe the Ministry of Human Services, in particular, the department that deals with counseling. And that system was created and located at the various centers I have just named, and once populated, will ensure persons who are manning the criminal justice system and in the various institutions that I have highlighted would be able to access persons' information, criminal antecedents, engagements in the criminal justice system, either the police station level, right up to the prison. So I will know whether Indira Ananjit had a brush with the law by typing in her name and some other identifying feature. That will tell me her entire relationship with the criminal justice system. That she had a ticket in 1980 or whatever it is. I mean, we may not be able to go back that far, but it will be prospective. And of course, we'll try to be as retrospective as far as we can be. I say all of those things to say to you that the concepts that I began alluding to, the rule of law, justice, law and order, so vital concepts, are all concepts that our government are absolutely committed to delivering to the people of our country. And what you're seeing here, and what you will continue to see on an almost everyday basis, is a manifestation and a demonstration of our government unqualified and unreserved commitment to the rule of law, constitutionalism, and the criminal justice system, and indeed the justice system of our country. I thank you very much, and I wish you all the best with the workshop. Thank you.